Hi everyone, I did not introduce myself again. Long time, it's been really long ever since we last posted, but we had it at heart. So today I prepared you something interesting that I want us to share or to talk about, and this is under land transactions fraud under land transactions. So everyone doing land transactions, you should come closer because we're going to talk about something so pertinent in land transactions, which is known as fraud. So I believe most of you know that actually the High Court Land Division has the highest case backlog in Uganda. So my question is, where have we gone wrong as a country, and how best can we mitigate cases arising out of land disputes? So all those questions shall be perhaps answered in this discussion that I'm having with you guys. So the law applicable, of course, we have the Constitution of the Republic of Uganda, and we shall start from Article 26, which talks about, or which provides for a right of owning property, either individually or in association with others. So we shall again talk about the Registration of Titles Act. So it's so prudent to know what type of land is protected or is governed by the Registration of Titles Act, which I shall abbreviate as the RTA. It is now cap 240. By previously it was at cap 230. Yeah, it was now revised. So what kind of land is governed or protected under the RTA? This is the registered land. Only registered land is governed by the RTA. So if you're a chibanja holder, I believe most of you have land, but I've never seen how a title or a certificate of title looks like. But you have land and you've inherited it from your mothers, fathers, grandparents, and all that, but you've never known how a title looks like, or you have never owned a title. So that means that you're not governed by the RTA. You're just governed perhaps by the Land Act or the Contracts Act, because you guys enter into an agreement. More especially you, the chibanja holders, enter into a contract of sale of land, right? Therefore, you're governed by the Contracts Act, not the RTA. A case in point is the case of John Katarikawe versus William Katwilemo, right? These guys entered into a contract of sale of land, but William, the defendant, did not do what? Did not provide instruments or documents effectual for for registration of his land to the plaintiff. When I talk about instruments effectual, I'm talking about the transfer forms, mutation forms, and all that. Because when you buy land from somebody who has title or who has a certificate of title, they must sign you transfer forms, right? So that you can effect transfer of that land from his name to your name, right? So that's a point in consideration. So you look at that case, and actually I would like to note something in that case. We were they 18 judgments in that case by second justice? Yeah, and the first ruling was that in law, an oral contract is ineffective as a written one by the Contracts Act. I know you know this. And a contract of sale of land is not perfected until an effective transfer of the title has been made, but failure to do so does not effect the contract until the land is transferred to another person. So this means that if you have bought land and you do not and somebody does not sign due transfer forms, that means that you only you will only you'll only proceed under the law of contracts for breach of contract. In case of anything, in case anything happens, you will only proceed under the Contracts Act, right, for breach, right? Because actually in that case they looked at equitable interests versus registrable or legal interest, and we all know that legal interest prevail over equitable interests. So you look at section 54 of the Registration of Titles Act. Yes, and a case, is it Ranga versus Registrar of Titles? Yeah, that case of Ranga versus Registrar of Titles, which tells you that you have to have a number of instruments or documents necessary for or to effect transfer. For instance, you cannot go with only your sales agreement to the registrar, to the land registry, and expect them to transfer land in your names. Of course, you need transfer forms from the vendor, consent forms from the vendor, perhaps mutation forms signed by the vendor, even a copy of a title, a chapa, a chapa, right? Okay, let's talk about section 59. So having gotten your chapa or having land registered in your chapa, you're protected under section 59, which is commonly known as the indefeasibility principle. I know most of you know this as the indefeasibility principle. What about it? What does this mean? This means that the law presumes that whosoever has a certificate of title in their names, the presumption is it is conclusive evidence that they are the true owners of that land, right? Are you guys at par? If you have a certificate of title in your names, the law presumes that you're the what? You're the registered proprietor of that land, and therefore you're protected under section 59 that nobody will do what? Will evict you, nobody will do anything because it's your land, right? It's conclusive evidence that you're the true owner of that land, unless otherwise. So that is the general rule. The general rule is oba oina a chapa. If you have a chapa, it means that it's conclusive evidence you own that land and you're protected from any sort of wrangles, eviction, whatsoever. You're protected. The reason being you're the registered proprietor. So let's look at the exceptions. Just like you know that every general rule attracts exceptions. We have exceptions to the indivisibility principle, and that exception we shall find it under section 64, right? We have a lot of actually we have a lot of exceptions under from the general rule. We can look at section 77, 64, 136, 176 of the RITA. But right now, I would like to draw your attention to section 64, which introduces to us something that I want to talk about, which is fraud, except for fraud. So you're protected under section 59, except for fraud. Are we together? You're protected if at all you have a title, unless you acquired that land fraudulently. Are you together? So that is the meaning of section 64 and 59. 59, the general rule, you're protected. 64, they're telling you you're protected. However, if we detect any sort of fraud, you're not protected, right? Under the indefeasibility principle. So what is fraud? What amounts to fraud? I know most of you have been victims of fraud, and sorry about that, but still some of you participate or engage in fraudulent actions, right? I'm talking this without prejudice. So the Registration of Titles Act does not explain to us what amounts to fraud. So case law or common law has done us well because they have gone ahead to give us given meanings or the scope of fraud. So let's look at the case of Frederick Zabwe versus Orient Bank Civil Appeal number 4. Actually, Supreme Court Civil Appeal number 4 of 2006. Mainly, we are looking at the decision of Justice Bart Katulebe as he then was, right? So I may not go into details of this case because it's a must read. Actually, no, I'll tell you this at the end of this recording about what you must not forget in land transactions. So this case, it's a must read case on everything, actually on everything in land transaction, because it will introduce to you powers of attorney. You will study powers of attorney under agency in land transactions. It will introduce to you mortgages. You have a topic called mortgages under land transactions. It has introduced us fraud under land transactions. So let's talk about fraud. What was defined? How was fraud defined under this case? So this case, in reliance to the Black's Law Dictionary. Am I being so fast? Sorry. Okay. This case, in a conjunction with the Black's Law Dictionary, defined fraud to mean the intentional perversion of the truth for purposes of inducing another in reliance upon to part with some valuable thing belonging to him or to surrender a legal right. So intentional perversion. What do you mean by perversion? Perversion. Do you have any other word to mean perversion? Yes. That word can be diversion. You're intentional diverting from the truth. Okay, for lack of a better word, I would like to explain this under misrepresentation. I believe most of you doing land transactions now did contracts law too, and we looked at vitiating factors, and one of them being misrepresentation. So misrepresentation, this is where one makes a statement inducing you to enter into a contract with them, but it so happens that that statement is wrong, right? So somebody intentionally makes a wrong statement which makes you enter, or which induces you to enter into a contract with them. So this is fraud as again, where somebody intentionally diverts the truth for purposes of inducing another, right? So another definition, still from the same case, a false representation of a matter of fact, whether by word or by conduct, by false or misleading allegations, or by concealment of that which deceives and is intended to deceive another. So you intentionally deceive another, right? Or concealment. Concealment means hiding something factual, hiding something of essence. You hide it from the other person, right? So in case of anything, you enter into a sales agreement, a land sales agreement, then you do not mention to that party that, you see what I mean, you know what, I'm not the true owner of this property. So that means that you're acting fraudulently. So still in the same case, they're giving us some incidents of fraud, which includes suppression of truth, tricks, cunnings, dissembling, and any unfair way which another person is cheated. So you cheat another person, right? So you could also borrow you could also borrow a definition from Katarikawe versus Katwiremo, which where Justice, was he Sakandi? Yes, he told us that fraud actually means dishonest dealing in land transactions. You dishonestly deal in land transactions. Are we together? Not forgetting the definition in Kampala bottlers versus Damanico, is it? Yeah, I don't remember, but it's Damanico. So that is fraud. It is of essence to note that lands are not what? Lands are not vegetables bought from unknown sellers. Lands are valuable properties, and buyers must or are expected to make thorough investigations not only of land but also to the so-called vendors or owners before purchase. So land is not actually, you'll find other cases telling you that lands are not tomatoes. Yeah, lands are not tomatoes bought from unknown sellers. You go to a market and just buy, I want tomatoes of 2K. You don't care whether the other person has title over the tomatoes or not. You just buy, and you do not want to know, right? Because, of course, what took you there is to buy tomatoes. Land is different, right? You should not only conduct due diligence on the land, but also the what? But also to the person selling to you, because anything can happen. Actually, in Uganda right now, anything can happen. Am I being faster again? I'm sorry. Anyways, let's look at particulars or elements or ingredients of fraud. It should be noted, you guys should study to understand, not to cram, because some of these things are going to haunt you again in fourth year when you get to fourth year doing, I think, civil procedure under pleadings. Civil procedure pleadings, they will tell you that in case your cause of action is perhaps fraud or negligence, you need to give particulars of that cause of action. Kati, if you did not understand the particulars or elements that constitute fraud, then I don't know. So you should understand what amounts to fraud. What are the particulars that amount to fraud? We have dishonesty. First of all, dishonest. And I told you in the case of Katarikawe versus Katwilem, we were told that fraud is defined to mean or to cover dishonest dealings in land. So in anything, dishonesty, this can include maybe concealment of the truth, anything amounts to dishonesty. So let's look at intention to cheat. There should be intention. Some other party must intend to cheat. I know you've looked at the case of Frederick Zawe, and actually you guys should read this case and understand it. In case you don't understand it, my email is no. In case you don't understand it, I'll make a recording to explain this case in details, because you need to understand it and find out where where fraud was seen, because this case went through the High Court and the High Court did not see any fraudulent dealings in this case, right? The same applied to the Court of Appeal, but this was only seen by the Supreme Court. So you should read this case and understand it carefully. So, intention to cheat. There must be intention. So you, when looking at that case, you'll see how the second defendant, Mars Company Limited, had the intention of cheating, because you cannot tell me that the other party has signed to me powers of attorney, right? And if I signed to you powers of attorney, any dealings you do or you make as the donee must be in the favor of me, the principal or the donor. But these guys use this person's property to secure a loan in order to pay their debts with National Water and Sewage Corporation, right? So there was intention to cheat. Another aspect under that case of intention to cheat was these guys, okay, they knew very well that after all, we are not the owners of this land, even if we do not pay our debt to completion. So that's what they did. They did not even bother paying the debt. That's why Orient Bank went ahead to do what? To sell the property, but that property did not belong to them, the second defendants. It belonged to the appellant, who was Frederick Zawe. So you need to read that case and understand it. So thirdly, apart from intention to cheat, there must be participation, right? But you must participate in fraud. So under participation and intention to cheat, we're going to see notices. What are notices? These are, we are going to see the three notices that may be so fundamental in determining whether a person participated in fraud or not, right? Okay, let's look at the actual notice. This is direct notice by either evidence brought to the attention of the purchaser or through conducting a search. Actual notice. This because they're telling you that you must conduct due diligence before purchasing land, right? So you go to lands, you conduct a search. A search is just 10K. You go to the land district, you give them the block number of that land and the plot number. So they'll give you results of who the registered proprietor is of that land, right? But you very well know that Joel is not the registered proprietor of this land, but he has some little interest in that land, right? But you very well know that he is not the one on the title, but you go again and do what? And transfer with him. Are you okay? And transact with him. Are you okay? That's actually not, because you very well know that Joel does not have title over this land, but you were like, reason being, the land that I want to transact is Joel. It belongs to Joel's mother, and Joel being the son, perhaps tuyinza okukola obukujukuju and we get that land into Joel's name. Are we together? So that's actual notice. You very well know. Secondly, we have another notice, constructive notice. Constructive notice, this is knowledge a purchaser would have acquired if he or she had taken reasonable steps to investigate the title. So constructive notice introduces to us what is called conducting due diligence. Have you guys read the case of which case? Matthias Konde Zimula versus Byarugaba. Is it Byarugaba Moses and Nampija who? Nampija something. Where you fail to conduct due diligence, we shall get you under constructive notice that had you conducted due diligence, perhaps you should have gotten to know that actually the person you're dealing with is not the true registered proprietor of that land, right? For instance, they are telling you that in order to before you purchase land, because it's not vegetables brought from from unknown sellers, you need to understand who is this person claiming to be the vendor. Is he or she the rightful person to sell to me this land? That was answered in the negative in the case of Matthias Konde Zimula versus Byarugaba. So what happened in that case? Mose, the plaintiff Matthias and Nampija were married, but things didn't go well in their marriage, so they decided to part ways. After parting ways, Matthias actually got to know that his papers were missing, his certificate of title, his chapa was missing. So what he did, a diligent person, he went to lands and acquired a special title, right? After acquiring a special title, kumbe Nampija, the wife, the divorced wife, had done what? Had purportedly signed powers of attorney from Zimula, Konde Zimula, being the husband, to her, giving her authority to transact that land. So she stole that land title. So she went with it. So how did court determine fraud? How can I sign you powers of attorney at the same time? At the same time, you as the donee sign as the vendor and at the same time as the purchaser, right? So that is what took place. So court was like, the second defendant cannot claim to be a bona fide purchaser for value without notice. Reason being, he did not conduct due diligence. Because had he conducted due diligence, in that, had he gone to the chairperson and perhaps made inquiries, or the neighbors, nababuza ko banange ono inanyi nitaka ebintu bino bidi kuchi, because local leaders know about anything that takes place in their jurisdiction, right? Even neighbors. So this is I can't sell to you land. I'm not the registered proprietor, and my neighbors do not know. At least go to my neighbors and ask them. Make inquiries. Actually, this was also the case in David Sejaka, right? These guys did not conduct due diligence at all. Okay, they did conduct due diligence, but still they did not inquire, right? Had they inquired, actually they should have gotten to know that Monange, this person that I'm dealing with, is not the registered proprietor. So this is constructive notice. Had you taken a step ahead and conducted due diligence, you should have gotten to know that indeed the person you're dealing with is not the true person you ought to deal with. Are we together? So constructive notice means that you have not conducted due diligence. So, and in case you don't conduct due diligence, trust me, you cannot claim to be a bona fide purchaser for value without notice. We are going to see this. Anyway, so that's constructive notice. Then, lastly, let's look at imputed notice. Imputed. We understand imputed notice that it's notice drawn from use of an agency. Joel is unable to... Okay, Joel wants to buy land, but he's very busy with school. So he appoints another person known as the agency. I mean the agent. So here, your law of agency comes into play. I appoint an agent to conduct due diligence on my behalf. And you very well know the principle under agency. He who acts through another acts themselves. So if I appoint a lawyer to conduct due diligence on my behalf, and that lawyer gets to know that this land that I'm dealing with, this person we want to transact with, he's not the registered proprietor, but that lawyer keeps quiet and does not tell you, trust me, you as the principal, you will be held liable you'll be vicariously, actually, for lack of a better word, you'll be vicariously held liable for the agent is keeping quiet because he concealed. So the presumption shall be that he who acts through another acted themselves. So if he keeps quiet, that will be imputed on you. It will be attributed on you. So in case you conduct, in case you are transacting with the person who is not the true owner, but you appointed Joel to conduct due diligence on your behalf, and perhaps Joel was bought, in quotations, bought, or kumugula bamuguze ne bamwaya kasente ne bamugamba, no, it's okay, tugenda kwaya kasente tukutule deal eno. You will not claim to be a bona fide purchaser for value without notice. Reason being, his negligence will be imputed to you. His notice will be imputed to you. But court will be like, you knew through your agent. So that is imputed notice. I would like to echo this. Actual notice means you actually conduct, you engaged in fraud. You knew but you went ahead to transact with the person who was not the registered proprietor. Then constructive notice means that you have not conducted due diligence. Had you conducted due diligence, you would have known that indeed the person you're dealing with is not the true owner of that land. Read the case of Matthias Conde Zimla versus Byarugaba Moses and Nampija. Was it Nampija Grace? Yeah, read that case. Then imputed notice. Imputed notice, you use an agent. So the law of agents comes in play. He who acts to another acts themselves. So in the case of David Sejaka versus Rebecca Nalima, in this case, the vendor used the advocates who were aware of the alleged fraud and did not notify the client, but this knowledge was imputed on the client. Right? This is what I've been telling you guys. You appoint somebody to conduct due diligence on your behalf, the presumption shall be that you also knew about it. If he concealed the fact from you, the law will attribute his knowledge to you or impute his knowledge to you. Right? So let's look at manifestations of fraud or aspects of fraud. How is fraud manifested? How do we get to know that there was fraud or there must have been fraud in this transaction? How do we get to know? One, let's look at falsehoods of status of land. Falsehood. If you declare falsehoods previously you would no, I'll explain this later. Anyways, here they're giving us a case. Betty Chizito versus David Chizito Kanonya and seven others. All of them that were called the Chizito because the defendants or the respondents were all children of the first respondent. So it was held that declaring that there were no developments on land in order to evade payment of taxes and therefore defrauding government of revenue consists of fraud. So previously, in case you did what in case you transacted, you would declare this transaction so that so that you pay stamp duty. Stamp duty is 1.5% of the value or of the subject, of the amount of money you paid. So people use this in order to pay little taxes. For instance, if I'm buying land which is very well developed, I'm buying land which has maybe buildings, a hostel and all that, the presumption is I'll pay a higher tax, a higher stamp duty compared to a person who has bought the same land which have no developments at all, right? So here they're telling you that declaring that there is no developments on land in order to evade payment of taxes and defrauding government of revenue consists of fraud. And in case court gets to know about this, that you intend to evade taxes, trust me, it will be a manifestation of fraud and you'll be done what? Your title will be impeached, right? Your title will be impeached. Anyway, secondly, let's look at consideration. First one we've talked about falsehood of status of land. Is land developed? Because you have to declare this land was not developed, this land was developed, and so on. So consideration still, I'll explain it or I'll borrow the explanation from the status of land. So consideration, in order to pay taxes, they'll ask you how much did you buy this land, right? How much did you buy this land? And you'll tell them, you'll declare to them how much you paid for this land. If it's 5 million shillings, they'll be like, okay, now 5 million shillings. You have to pay stamp duty of 1.5% out of the 5 million shillings. So 1.5 divided by 100 times 5M, I think that's 75,000, which you have to pay to government. But people, in order to pay less taxes still, they declare less consideration, the amount of money. They declare false monies or amounts of money in order to run away from taxes, right? Katim. This is so practical in that if I want to buy a building or if I want to buy a plot of land in Mokono near UCU perhaps, which has a hostel, and I buy it at perhaps at 100 million shillings, and I upon declaring, if I make not even a mistake, if I intentionally, instead of 100 million, I put 10 million shillings, that will be a red flag. And if court gets to know that there was fraud or you declared a less amount of money than that you actually bought, that will be a manifestation of fraud. Are you trying to get me? You bought something at 10 million shillings, but you're telling government, no, I bought it at 1 million shillings. There is a case. There is this good case of Issa Mudima. Mudima Issa and two others versus Eli Kayanja. You know Eli Kayanja. That case is an interesting one. I would advise you to read it because it's a very interesting one. So this guy buys land. No, actually, these were the brief facts of this case. Joel has a problem with maybe he's okay, Joel is a chibanja holder, but he has a problem with his landlord, right? Then he runs to General Eli Kayanja and he's like, General, kindly help me because you have a deeper hand in government. Kindly help me. I have conflicts with my landlord. But thinking that General Eli Kayanja will help you, reason being he has a deeper hand. Mama, after a month, then Eli Kayanja comes to you and tells him, you know what, I bought this land, therefore I'm chasing you from this land. And you're like, Banang, I came to you for help, and now you're the one chasing me out of this land. So those were the facts of the case. So in that case, I think there were over thousands of squares of land, something like 1,000 or 100 squares of land, square miles actually of land. Then in declaring the consideration, Eli Kayanja said, or the respondents, the defendants said that they bought all of that land at only 10 million shillings. 10 million shillings. Now, you guys, do you know over 100 square miles of land, buying them at 10 million shillings in total? Are you okay? So, back to my point, ordering my point home. If you declare a false amount of money, which is so different to the one you paid for consideration, it is a manifestation of fraud. You also look at the case of Samuel Chizito Mobiru versus Biensima and another High Court civil suit number 513 of 1982. The plaintiff inserted 500,000 in the sales agreement as purchase price for land when in fact he paid 2.4 M. You see this? Right? So I also have here the case of Mudima Issa versus Eli Kayanja. The same thing. The defendants deliberately understated the value of the suit land worth billions of shillings to be 10 million shillings. This case, it's a must read, guys. Read it. It was said that the defendant's certificate of title is void of fraud or fraud. Right? So this is declaring or understating the value of the suit, the value of land. So if it's 10 million, kindly tell them that this land, I bought it at 10 million shillings so that you do not deprive government of revenue. Right? So was the case in Betty Chizito versus David Chizito. Actually, this was a civil court of appeal, civil appeal number 8 of 2018. It is an interesting case as well. You should read it. Anyways, another manifestation is multiple transfers. Have you guys ever looked at a copy of a certificate of title? A chapa. So, let me open my chapa here. Here, you open it on the front page. It has Uganda Registration of Titles Act, Certificate of Title, District, Wakiso, County, Busiro, Block, and Plot. Then, if you open the second page, has ownership, property, about the property and ownership. So you'll see date and time of registration, instrument number, ownership, owner's number and address. Owner's name and address, clan, and signature of registrar. So here we are talking about multiple transfers. So in case there are multiple transfers on the same piece of land, maybe in a small duration, in a small period of time, perhaps in a month, we have over 10 transfers. Doesn't that create red flags? Of course, Coco to be like, but you guys, what prompted you to transfer 10 times in a duration of only 1 month? Are you guys trying to understand? So this is also a manifestation of fraud because it might be a red flag. What are you trying to transfer? You've transferred today. After 2 days, you are transferring. After you're just transferring. Even land, the land district, the district land board will be like, but this person, is there anything hidden? Is there anything fraudulent taking place? So those are multiple transfers. You better look at your title. Okay, you will get a copy of a title and look at that page of ownership, which is part 2. Then failure to make inquiries is also a manifestation of fraud. So I would revert back to the case of Matthias Konde Zimula versus Biaruhanga. Biaruhanga was the second defendant, actually the first defendant. He claimed to be a bona fide purchaser for value without notice, because if somebody says that, if somebody claims that you acted fraudulently, the only defense we have is one: I was a bona fide purchaser for value without notice. We are going to look at it, right? So Bialugaba, the first defendant, could not claim to be a bona fide purchaser for value without notice. Reason being, he had failed to make inquiries. This is due diligence. Failure to conduct due diligence is a manifestation of fraud. Are we together? You fail to conduct due diligence, then toina chotugamba. Because lands are not vegetables bought from unknown sellers. Actually, there is a question, I think it was given in a coursework some year, that it was in a quotation: lands are not vegetables bought from unknown sellers. Lands are valuable properties where the buyer is expected to conduct investigations on not only the land, but also to the owner themselves before purchase. Close quotations. Per Justice Okello in the case of Sir John Bagaire versus Awusi Matovu. This is how we should attempt it, the way we started. Anyway, so my point was failure to make inquiries. If you fail to conduct due diligence, it's a manifestation of fraud. Okay. Having looked at that, let us look at the effects of fraud. What is the effect of fraud? Effects of fraud. Previously, we would cite it as section 77, but right now it's section 76. That your title is impeached. Failure to conduct due diligence, your title is impeached. Therefore, you cannot claim to be protected under section 59 of the Registration of Titles Act. I think I should read this, right? Section 76. Previously it was section 77, but now it is section 76. I'm looking for it. Section 76. Okay, here it is. Certificate void for fraud. Any certificate of title, entry, removal of encumbrance, or cancellation in the register book procured or made by fraud shall be void and as against all parties or previous to the fraud. So in case we find out, before I even get to that, it should be noted that once fraud is pleaded and proved, it vitiates contracts, judgments, and all transactions whatsoever. This was held in the case of Frederick J. Kezawe versus Orient Bank and 6 others. So in case fraud is pleaded and proved, it vitiates contracts and all transactions whatsoever, right? So you quote the section 76, certificate void for fraud. So you're no longer protected under section 59. So what happens after? Section 76 is section 177. It grants the High Court powers to order the Registrar of Titles to cancel your name of that title and institute the other person whom you defrauded back on their title. And so as the case in the case of Matthias Konde Zimula versus Bialugaba Moses. Those cases are so good, you guys should read them, right? So what you shouldn't forget about before giving a conclusion, let's look at the only defense we have under land transactions. It is only one defense that we have under land transaction. Under fraud. It is bona fide purchaser for value without notice, right? So in the case of Chizito Mobile versus Biensiba and another High Court civil suit number 513 of 1982, bona fide was defined to mean good faith and honesty without fraud or collusion in participating in wrongdoing. Remember, under the elements or particulars of fraud, we say that in order for you to be proved to, in order to prove fraud, you must have acted dishonestly, had intention or motive, ill motive to engage in fraud, and lastly, participation. But here I should show court, if you are the defendant
who perhaps acted in good faith and bought from another person who had title, you should show court that, you know what, I acted in good faith and I'm a bona fide purchaser for value without notice. Therefore, do not take my land, but deal with the other person who defrauded you. Right? Deal with the other person who defrauded you, not me, because I bought land in good faith. So this is what bona fide purchaser for value without notice and entails. So let's look at the elements of bona fide purchaser for value without notice. I'm sorry I'm being a little fast because my time is fast spent, but I believe we can understand. You can always revisit the page if at all you've not understood, or perhaps inquire. Anyways, elements of bona fide purchase for value. These elements were stipulated in the case of Conde Matthias Zimler versus Biarugaba Moses and Grace. Actually, she's called Grace Nampija, High Court Civil Suit number 66 of 2007. Actually, it was 2006, though decided in 2007, decided in 2014. Yeah, 14. Okay, let's look at the elements. They're telling us that person claiming to be a bona fide purchaser for value without notice must have a valid title from a person registered as the proprietor or owner. So the first thing you must prove to court that I bought this land from a person who had title over this land, or I bought from Joel in whose name the title was, right? That's the very first thing you must prove. Then secondly, must have paid valuable consideration. You must have paid some money. Sigamanti I gave you a gift. Sigamanti you got it through a gift. No, you must have paid some money in order to qualify as a bona fide purchaser for value without notice. Then lastly, you must have acted in good faith without notice of fraud, whether actual, imputed, or constructive. You must have acted in good. You don't know anything about these the fraudulent transactions by the person from whom you purchased this land. Are we together? Let me re-echo this. One, you must have bought from a person who had valid title, right, or a registered proprietor. Then secondly, you must have paid valuable consideration. Lastly, you must have acted in good faith without any notice of fraud, whether actually imputed or constructive. We've looked at these, right? Okay, there is a case I'm looking for. I don't know. Actually, you could also use the case of Betty Chizito versus David Chizito for this. For these elements, they will explain to you these elements very, very what? Very well. So this is fraud. So in case you no. Okay, I'm not going to take you through caveats, but let me just talk about it. So in case you find out that actually somebody acted fraudulently and transferred my land in their names, or I lost a title, just like the case, just like it was in Matthias Conde Zimler, I lost a title, then I discover that actually somebody else has got a special title and transferred my land in their names, so I may lodge a caveat. You will look at caveats in details and you will get to know the particular type of caveat you must lodge at any one given point, because we have 4 types of caveats and they are all used differently, right? Anyways, so this is what I wanted to tell you previously, that you should not forget certain things under fraud or land transactions. One of them, read these cases in details. Read these cases. And for fraud, specifically fraud, read these sections. One, you begin with section 59. Section 59 tells you that you're protected, the indefeasibility principle. You're protected if you have title, if you have a valid chapa, you're protected under section 59. We have an exception under section 64. They're telling you that in case we discover that you've been fraudulent, or you acquired this land fraudulently, you will not be protected. It is an exception from the indefeasibility principle. Then, thirdly, in case we get to know that actually you participated in fraud, we shall go under section 76. Your certificate shall be void, right? After knowing that your certificate is void under section 76, we shall go under section 177, which gives the High Court powers to direct the Registrar of Titles to do what? To cancel out your title and reinstitute the other person whom you defrauded from right? To have them instituted back on your title or on their title. Okay, omuntu gwe wabbyeko ekyapa oba n'okyusa ekyapa ne kidda mu mannya go, oyo omuntu under section 177 the High Court shall order the Registrar of Titles to reinstitute them back on what? On their land. So, I mean on their land title. So, I do not want to leave without mentioning something small. We have remedies for fraud. Remedies, one of the remedies is section 177. Your land is, 176, 76. 76 tells you that your title is void, right? Is void, under section 177, right? Then secondly, you can ask for damages. We have these so-called main damages. They're called main profits or damages. I know most of you will pronounce it as mezine. It is MESNE. It's main, it's pronounced as main profits or damages. So these are like specific damages, but they only arise where perhaps you've had a person had property on their land, like rentals, abadene hostels, rentals, another person wanted to defraud, another person defrauded him and maybe transferred their title into their names. So that person natandika okufuna rent mu hostel zone omuntu. You can't tell court that Munang, I want my money, because from the date he got possession of my land, he's been collecting rent from my tenants. Therefore, I want my money that he has been collecting. Those are called main profits, though they must be strictly proved as though there are special or specific damages. Are we together? So you shouldn't forget section 59, indefeasibility principle, section 64, exception, section 77, effects, and section 76, effects, and section 177, effects of fraud. High Court. So I believe most of you have a question that, okay, what if we didn't go to the High Court, but it is the Magistrate Court which found that actually the other party acted fraudulent. Yet the Act says that it's only the High Court which has powers to order the Chief Registrar. Is it Registrar? Yeah, Registrar of Titles to cancel. The other one is title. Yes, they'll still send you to the High Court so that you get that order. It's an order, right, directing the Registrar of Titles to actually cancel the other person's name and institute your name, right, and you're given a title. So, thank you very much for listening. I hope fraud has been kind of made easy. Yeah, don't forget to read those cases. They're so good.